Please rise.
Thank you. Please be seated. All right, we're on the record on this matter, State of Idaho versus Alan Douglas Bruce. Mr. Bruce is here present with his attorney, Mr. Archibald. Mr. Rogers appearing as prosecuting attorney for Custer County. Mr. Bruce, you previously appeared before the court and entered a plea of guilty as an Alford plea pursuant to a plea agreement to the amended charge of second-degree murder. You also entered a plea of guilty to count 2 of the amended information, charging you with destruction of evidence. The state dismissed the balance of the charges, including the persistent violator charge as part of the original charges in this case. The court accepted your plea of guilty and entered it in the record, and I set today for the time and place of sentencing on somewhat of an expedited basis. Typically takes a little longer than this to get a matter to sentencing because of the time needed to prepare a pre-sentence report. In this case, we did get an agreement with the probation office to expedite that process, and so we did receive a pre-sentence report in a fairly short time frame, and that was filed with the court on November 10th. And Mr. Archibald and Mr. Rogers, I assume you received your copies of that report, correct?
Yes, Your Honor. Yes, Your Honor.
Are you all prepared to proceed with sentencing today, Mr. Rogers?
Yes, Your Honor.
Mr. Archibald?
Your Honor, in reviewing the pre-sentence report with my client, I was able to get to Salmon to do that on Friday. So we reviewed the report together on Friday night and Saturday morning. And my client would like to withdraw his plea. So I apologize to the court. I didn't have time to prepare and file a motion. So my client would like to be heard on withdrawing his plea and proceeding to trial.
All right. Well, counsel, I guess due to the status of this case, and we feel like we addressed that issue at the time Mr. Bruce entered his plea of guilty, that the process that I went through with him at that time and placed him under oath to ask him a number of questions regarding the entry of his plea, whether his plea was being freely and voluntarily entered, if he understood the terms of the plea agreement that were in place at that point in time, the rights that he was waiving to enter his plea, and really the timing of all of that with the trial. It was originally set at that time, was set for just the following week, I believe, to begin on, I think, November 4th, that we would have otherwise been proceeding to trial as he had been requesting, without waiving his right to a speedy trial. And I indicated to him that the difficulty it would be for him to change his mind and to withdraw his plea of guilty. And I believe I advised him at that point in time that the standard, since this is a plea agreement that's intended to be binding on the court, and so at the time he entered his plea, he was aware of what the sentence would be in this case if the court followed the plea agreement, that the standard would be for the court to apply in determining whether to allow a withdrawal of a plea would be, in my view, would be manifest injustice, which is a much higher standard and burden to meet, to withdraw a plea of guilty under those circumstances. Now, I'm aware of the case law in the state of Idaho that says the court should look with favor, or maybe not those terms, but look with some leniency to allowing the withdrawal of a guilty plea. But I think the circumstances of this situation and the history over the last 2 or 3 months, where we have appeared twice really for entry of a plea, back at the end of September, where there's a similar situation where a plea agreement had been entered into after mediation, and we appeared in court, and you advised the court that your client had changed his mind and no longer wished to enter a plea of guilty. And so we set the matter for trial at the week of November. It had already been set, back in July. We set the trial for the first week of November. Your client was requesting to be kept on that date, and so we did so, and everyone was preparing for trial. And then a week before trial, approximately, this new plea agreement was entered into, and your client entered a plea of guilty after a fairly lengthy discussion with the court under oath. So I'm not inclined to grant that request today, and I would intend to proceed forward with sentencing, and I guess it could be addressed at a later time, and you've made your record today, Mr. Archibald, what your client's desire is. Mr. Rogers, does the state wish to make a record or have any position on the matter?
Yes, thank you, Your Honor. I echo most of what the court says. I also, just to highlight that at the change of plea sentencing, the court did give notice of its intent to accept the plea agreement and was waiting for today to finish the sentencing on that. And I think what the court has addressed under Idaho Criminal Rule 11F, nothing has been warranted for a withdrawal of plea at this point, and I think the rule is sound on that along with the case law. So other than that, I would echo the court's sentiment. I would ask for the court to deny the motion.
All right, so we're going to go ahead and proceed with sentencing today. Only reiterate what I did say at the change of plea hearing, is I did feel like we needed to recognize the victim's rights and the rights of the victim to have their input at the time of sentencing, and the court wanted to hear their comments, but I did indicate at that time that I was intending to accept the plea agreement, but wanted the victims to have a right to make their statements in court. So in any event, that's the order of the court, and we're going to go ahead and proceed with sentencing today, counsel, and obviously you can proceed thereafter with whatever process you feel you need to take. And as I've already stated for the record, the rule provides that you must show a just reason for a withdrawal of a plea. That hasn't been shown to the court, and I would intend to proceed today, but I also think the higher standard applies of manifest injustice if you attempt to withdraw your plea of guilty after sentencing. And although sentencing has not occurred yet, it was understood what the sentence was going to be in this case when Mr. Bruce pled guilty, and so I think, in my opinion, that same manifest injustice standard should be applied. So in any event, we'll proceed with sentencing. So I guess, Mr. Archibald, are there any parts of the pre-sentence investigation that need to be clarified or corrected?
Yes. On page 1 of the pre-sentence investigation report, where it indicates that a DNA collection is needed, Mr. Bruce reported to me that he has already provided a DNA sample.
I mean, where is that reflected on not page 1?
Under the name, address, Lehigh County Jail.
I do see where you're referring there to. So that he's indicating he's already provided that?
Yes.
All right. Well, as far as correcting that or changing that, I'm going to leave that to the Department of Corrections to check their records. If he has already provided it, then he will not have to do it again. But if he has not, then he would be required to do so. So I'm not going to change that particular entry.
And the criminal history is where there are a lot of corrections. So turning to page 12.
Give me just a minute to get there. All right, go ahead.
Mr. Bruce indicates that there must be another Alan Bruce in California because the Alan Bruce seated next to me says that he only has 2 prior felonies, not 5 prior felonies. And so going through this, the second charge listed from the start, where it indicates prior record in the year starting in April of 2000, taking a vehicle without owner's consent, a felony. Mr. Bruce indicates no, that is not him. The next crime.
Give me just a moment, counsel. I'll make some notation to the pre-sentence report. I'll have you go through these. I'm sort of just trying to decide if I'm going to change or correct anything here because I don't know, and I'll ask Mr. Rogers if he knows or not when we're finished whether these are accurate or Mr. Bruce's understanding of this record is mistaken, and so I have to kind of rely upon the records, the NCIC records, and to see what is there. But if something is not him, then that's going to have to be corrected. But I don't know if I'm in a position today to say yes, we're going to strike that one and remove it because I don't know if that's really the case. But go ahead and go through your corrections you feel need to be made.
And that's what I indicated to Mr. Bruce, is that it wouldn't affect the sentence today because we already have an agreed upon sentence, but it could affect his conversations with the parole board.
And I understand that. I may just make a note here that Mr. Bruce disputes the accuracy of this prior record and that the Department of Corrections should thoroughly check that and research it to ensure that they have an accurate picture of that prior record without going through each one piece by piece. So I will make that note, but you can go ahead and make your record.
And then the third crime listed on page 12, the carrying a concealed weapon, it says it was dismissed, but again, he says no, that was not him. The next charge in April of 2002, a battery with serious bodily injury, a felony. That charge was dismissed, but again, he said no, that was not him. The next charge in May of 2002, the bottom of page 12, battery with serious bodily injury. That charge was dismissed, but again, Mr. Bruce said no, that was not him. Going to page 13, the top of page 13, in December of 2002, carrying a concealed weapon, a felony. Mr. Bruce says no, that is not him. The third charge down from the top of the page on page 13, in March of 2005, Mr. Bruce indicates no, that is not him. A misdemeanor, being under the influence of a controlled substance. The next charge down, September of 2005, it says no dispositions listed, but in any event, Mr. Bruce says no, that was not him in September of 2005. The bottom three on charges on page 13 in August of 06, November of 06, and February of 07. Mr. Bruce indicates that is not him. Then turning to page 14, the November 2007 charge, even though it says no dispositions listed. Mr. Bruce indicates that was not him in November of 2007. So on page 15, where the prior record summary, it says that Mr. Bruce has the second sentence after the prior record summary. It says 5 of those crimes are firearm related felony convictions. That's where Mr. Bruce disputes that, and he has 2 prior felonies, not 5.
And counsel, I'm going to just make a written notation on the pre-sentence report that will then go with this case and be, the Department of Correction will have access to that. I'm just going to make a note to the effect that Mr. Bruce disputes a number of the entries in his criminal history. He believes that he only has 2 prior felony convictions, and that the accuracy of this criminal history needs to be thoroughly reviewed. So I'll make that notation on the pre-sentence report itself as to that correction or clarification your client is asking to make. And again, I'm not in a position to say whether you're correct or not without researching and looking at that criminal history. So go ahead, counsel. Are there any other objections or corrections?
Those are the only requested corrections for the pre-sentence report.
All right, Mr. Rogers, did the state have anything you need to clarify in the pre-sentence report?
No, Your Honor.
Do either party intend to call any witnesses today, or are there going to be any victim statements today, Mr. Rogers?
Yes, Your Honor, there are 2 victim impact statements to be given by Patrick Shelton's daughters.
All right, and Mr. Archibald, were you intending to call any witnesses today?
No, Your Honor.
All right. Well, we need to proceed with the statements of the victims first, and then I'll hear the recommendations of the parties. So, please have these individuals come forward and make a statement. All right, will you please just start off by please stating your name and your relationship to Patrick Shelton.
Hello, my name is Shay Shelton, and that's S-H-E-A, and then S-H-E-L-T-O-N, and I am Patrick Shelton's oldest daughter.
All right, go ahead and make your statement.
Right. Hello, Your Honor, thank you for your time and the opportunity to speak today. My name is Shay Shelton. As I said, I am Patrick Shelton's oldest daughter, and I'm here to talk about a man that I've loved my entire life. A man whose loss has changed and will continue to change my entire life. Like many kids, my dad has been my hero my entire life, and I wanted to be just like him. This larger-than-life man was many things to many people, but for me,
Can I interrupt you just for a second to maybe kind of
Slow
slow
down.
down, take your time?
It's all good.
The court reporter is trying to take a verbatim record of this, and it's kind of hard to keep up. So just, I know you're a little nervous, just kind of take your time and read your statement.
All right. I will restart the paragraph. Like many kids, my dad has been my hero my entire life, and I wanted to be just like him. This larger-than-life man was many things to many people, but for me, he will have always been my dad first, and I would like to take some time to talk about the things that made him great. He was a passionate, intelligent, and kind man. A man who took time to visit single moms around birthdays and on the holidays to make sure that they had everything that they needed. From food on the table to the gifts that kids have been begging for but remained just out of reach financially. He did this not out of obligation, but because he could, and he knew how important these moments could be, especially as someone who grew up with a single mom himself. He was never too busy to be a helping hand when it was needed, no matter the task or the time or what project of his own he needed to drop to be available. My dad and I were similar in many ways, from interests to hobbies to a fondness for sports teams that were never very good anyways. 2 things that he passed to me that I will always hold core to my being are sports and a profound love of books. He was a gifted and accomplished athlete and split his skill over multiple sports throughout his life, often at the same time. When I began to show interest in sports, it was him who encouraged me to try anything that sounded even a little bit interesting. And it was him who reminded me that loving the game and the ways it connected you to yourself and to others was always going to be more important than any amount of points or wins. This, of course, did not stop him from cheering louder than anyone else in the crowd when those wins or points happened to occur. My entire life, both of my parents have been prolific readers, and books were a central part of my childhood and now remain so in my adult life. So there was never a shortage of stories, but me and my dad shared a common love: fantasy novels and the power of storytelling. Some of my first favorites came secondhand and love-worn from his collection. They were stories of heroes and villains, of impossible feats and rich magical worlds. They were also stories of good and evil, and how good would always win in the end, how you had the power to change your fate if you believed hard enough and tried your best. There are 100 things I could name that I loved about him, and I will always be proud of the things that he passed on to me. A deep and lasting interest in sports, a love of storytelling and curiosity for the world, an intense competitiveness when it comes to foosball, being a loyal friend, knowing when you need to stand your ground, and the understanding that if you have the ability to help someone, you also have the responsibility to do so. These were the things that made Patrick Shelton who he was, and I hope that people remember me the same. Like any other person, he was flawed and complicated and got caught up in his own life. Likewise, I am flawed and complicated and prone to getting caught up in the distractions of my life. This caused a period of time where my dad and I weren't talking much and didn't have much time to be present for each other. 2 weeks before the events of May 8th, I noticed that my dad had reached out twice to check in on me and I had missed the messages. Months had passed since the messages had been sent, and I was busy at the time making plans for my mother to come visit for the upcoming Mother's Day weekend. I told myself that I would send a message back once things were settled. Later, soon, but later, and we would talk then. I didn't know that our later would never come. May 10th, 2025 is a day I will never forget. I had just recently come home from a Mother's Day celebration with my mom, my aunt, and my grandmother when my mom pulled me aside and told me that she needed to tell me something, that I should sit down to hear it. She told me that my dad had been reported missing and hadn't been seen for days. I would not wish what followed this moment on anyone. The knowledge that someone you know and love is missing is hell. Every minute feels as if it stretches hours, every second filled with countless scenarios and flashes of all the ways they could be hurt, or lost, or scared. As the time stretches, you understand that the chances that they're found alive dwindle to nothing. Then it's hours and hours of the ways that they could have died. Your desperate pleas of, please find them alive, let them be safe, let them come home, change to pleas of, please find him, any of him, let there be something left to be found. You don't eat, you don't sleep, you barely breathe. Days of this pass. What food you can choke down tastes like ash. What sleep you can find is filled with nightmares, or worse, the dreams that make it seem like it had all been some misunderstanding. His knock at the door, his voice on the phone saying, sorry for making you worry, but it's all okay now. A few days after the news that he is missing, Alan Bruce is arrested and the probable cause affidavit is released, and shortly after picked up by local news stations. And this is how I find out what happened to my dad. A news article entitled Shoot, Shovel, and Shut Up on a website tells me that not only is he dead, but he was murdered. And not only was he murdered, but he was shot, dismembered with a chainsaw, burned, and thrown into the river like trash. Worst fears become reality. He's dead, and the hope of anything ever being recovered disappears like smoke. The only thing left of my dad are fragments of his skull picked out of the truck he was murdered in by the people who loved him. Those fragments now sit in a cold box in a state lab where they will likely stay. To lose someone is never easy. To lose them to murder, another thing altogether. Then to know that his body was treated so horrifically following his death creates a wound that is impossible to put into words. A wound that can never shrink or heal because there is no body to bury, no ashes to spread. Nothing that would allow the people who love him the chance to say goodbye, to hold something that proved that he was here. No ritual, no closure, and nothing to help cope with the pain of that loss. And then Alan Bruce, the man who murdered my father, sends a letter to my sister saying that he's done us all a favor by dismembering him and destroying what was left. Saying that we probably couldn't have afforded a funeral anyways if there had been a body to bury, so at least he saved us a quick buck. It's disgusting and pathetic, and it reveals a person who shows no remorse for what he's done and the people he's hurt. It exposes the ugliest a person can be. 3 weeks ago, I turned 25 years old. 2 days ago, my dad would have turned 48. And in 3 days, my sister will turn 18. 24 is very young to lose a parent. 17, even younger. I will never get to ask my dad what lessons he learned at 25, and he will never get to tell me what he learned at 48. I will never get to ask him for guidance or a story about 24 years worth of living. I now face the rest of my life not only mourning the man that he was and the memories that we made, but all of the memories that we never got a chance to make, and the man he never got a chance to be. I will never again be able to find anything else that we have in common. I will not get to see any more parts of him echo in me that are not already there. I will never beat him in a game of foosball. He will never meet my partner, or my children, or see 1,000 other things that we could have shared. And that will be a new wound and a new grief every time for the rest of my life. Thank you.
Thank you, Ms. Shelton. Thank you for your statement. All right. Counsel, just a moment. Let our court reporter come in and have a seat. I apologize. I couldn't see over the bench here to see that our court reporter wasn't present. Just give him a moment to get set up, and then we'll discuss some of these matters we've discussed previously. Put that back on the record. So we're on the record on this matter with Mr. Bruce. Our court reporter had to travel and make the same trip as me from Salmon. Been busy all morning in Salmon with court. Had a long day there and had to hustle to get here from Salmon. The record will just reflect that we did record some initial portions of these proceedings on an FTR, and we'll have a transcript available of those proceedings that were recorded on the FTR system. We addressed initially a request by Mr. Bruce to be allowed to withdraw his plea of guilty, and the court made a ruling on that matter and denied the request and indicated we're intending to proceed with sentencing. We went through the process of some clarifications or corrections to the pre-sentence report. And now just completed the first victim statement from Shelton, who's the oldest daughter of the deceased Patrick Shelton. And so we'll proceed now to have the additional victim statement to be presented. Mr. Rogers, who do you wish to make a statement now?
Yes. You ready to go?
Yes. All right. If you can go ahead and just state your name and just also just kind of take your time in speaking so our court reporter can make a record of these proceedings. So go ahead and state your name first.
My name is Hope Shelton, HOPESHELTON.
And you are Patrick Shelton's youngest daughter. All right. Let me go ahead and make your statement.
Hello, Your Honor. Thank you for letting me speak today. As stated, my name is Hope Shelton. I'm here today not only as a grieving daughter, but also as an advocate of justice on behalf of my father, Patrick Shelton. This is by far the hardest thing I have ever had to go through within my 17 years of living. When I first got the news about my father being missing, it was a Friday, around 1 in the afternoon. My heart sank. I prayed it was all a big misunderstanding, that my dad was okay, that his truck had broken down, that his phone died. Immediately, I called out of work to go looking. When I saw the truck parked up Big Hill, I knew something wasn't right. I spent the next couple of days of searching for him, praying I could find him, hiking up and down that hill and the surrounding area, praying, trying my best to remain strong for my family, for my dad, getting cuts and bruises from falling in the sharp branches, but knowing that whatever happened to my dad was far worse. So I pushed through, praying that I could make it to him on time. My prayers went unanswered. On May 12th at 4:36 p.m., I got a message from one of the investigators asking if me and my mom, Shannon Garrison, could come down to the sheriff's office. I didn't think anything of it. I thought simply that they had more questions. Never could I have expected for them to pull me into the back room and tell me that my dad was gone. Hearing that news and watching my mom receive that news as well was gut-wrenching. It felt as if someone had stuck their hand into my chest and was trying to rip my heart out. I tried my best not to cry. And then, walking out of the back room and seeing his murderer take his mugshot, I couldn't look at him. My heart broke that day. I'm not sure if it'll ever be whole again. Every day it feels as if it breaks a little more. It breaks when my friends invite me to go swimming and I have to awkwardly explain how I can never look at water the same way. It breaks when I see someone with a similar feature to my dad and I have to remind myself it's not him. When I have to drive by where he got murdered, it breaks a little more when I remember I can never go to breakfast with him again. It breaks a little more when I have to correct myself when talking about my dad. Instead, I have to say he was. It breaks a little more when I can't talk to him about my car issues. And then there's times where it breaks a lot. Like when I had to read those articles detailing the crime. When I had to read people's comments about my father. Like when I had to graduate high school 2 weeks after he was murdered. When I got accepted to college and I couldn't tell him. There's so many moments my dad will never be there for. Walking me down the aisle, meeting my kids, watching me buy my first home. Both little and big moments that were stolen from me. What he did to my dad was cruel and vile. Did it make him feel better when he stalked him like prey for hours? Did it make him feel better when he asked him, "Do you want some of this?" while pointing a gun at him? Did it make him feel better pulling the trigger? Did it make him feel better when he took a picture of my dad after he killed him? Did it make him feel better when he cut him into pieces and burned him? Did it make him feel better when he dumped his ashes into the river? Did it make him feel strong? He claims self-defense, and yet his actions speak nothing of self-defense. What he did was calculated. He made a choice. My dad would never have done this to him, to his friend. He stole my dad's choice of making things right, and he continues to harm him even after killing him. Dragging his name through the mud, he stole everything from him. He stole not only a person's life, but a father, a brother, a son. He stole my father away from me. And then he has the audacity to write me a letter. 18 pages, front and back, of complete nonsense. In 18 pages, he wrote horrible things. He asked me how much money we had to spend on funeral services. I would give up all of my money to be able to have a body, to have the choice of a funeral. Instead, he dismembered my father and took that choice away from me and my family. Even now, he can't take accountability. He's a coward and a liar, and I don't want his apologies. I don't want his useless letters. I want him to drown in his guilt as I drown in my grief. I want him to drown in that guilt until the day he stands in front of his maker and is sent to hell for the atrocities he has committed. He doesn't get forgiveness for things that never should have been done. He's a murderer and a monster who deserves nothing less than to burn in hell for his choices. Thank you for your time, Your Honor.
Thank you. Thank you, Hope, for your statement. Go ahead and be seated. Thank you. Any additional statements, Mr. Rogers?
Not from the statement.
Mr. Archibald, I think you indicated you do not intend to call any witnesses, correct?
That's correct.
All right. Well, I'll just, I guess, indicate for the record, I want to hear counsel's argument, and I've already indicated the court's intention to follow the plea agreement in this case, but Mr. Rogers, I want to hear your sentencing comments and recommendations.
Thank you, Your Honor. I appreciate that. I think a plea agreement such as this deserves some explanation, probably to the community and also to the court. First of all, this is a very unusual and a one-off type of plea agreement. And it's one that involved the families in discussing it, and it's also one that I would never sign if the family was not involved and on board, and in turn, it's one that the family would never sign if I wasn't on board with them. So it was kind of a circling discussion that we've been having for the last few months, and it's been an emotional toll for everyone involved, including law enforcement, the girls' mothers. Just been a big back and forth. So it was difficult to know exactly with this type of case what the right thing to do was for the family, for the community, and for Custer County in general. This agreement never would have gone forward if the defendant was just a few years younger. This is something that was highly contemplated in coming to this agreement and the conclusions that we presented for the court. Another issue that we kind of ran into, and this was a very unusual circumstance, based on the court's retirement that we've talked about and the time frame that we've had. Just an unusual situation where we've, from the time of the filing of the initial information to when we were supposed to be at trial 2 weeks ago, was around a 4-month period, and that was a little bit of weight, and we took that into consideration in determining the plea agreement.
Counsel, I guess in that regard, I kind of want to make clear that, there were requests to give you some additional time, but the reasons you were giving the court were never framed in the sense that you were being prohibited from accessing evidence that you needed. For example, where there's still lab testing that you didn't have access to, forensic testing that still needed to be conducted, witness unavailability, really just in the sense that the state was being prohibited from presenting their entire case if I didn't give you some additional time. It was really only presented to me in the sense that you personally felt that you needed a little more time to prepare for the trial, to kind of be ready, in the sense that you're kind of trying this by yourself and that type of an issue. And of course the trial had been set since July. I know that there'd been a lot happen in the meantime. There'd been some mediation that occurred that sort of interrupts trial preparation process. And so I understand you were put in the process of, you were put in a situation of really having to work hard to be ready for a trial. But we were working within the constraints of speedy trial, and the court needed to recognize that. I know my retirement played some role into that, but I just wanted to make clear that had you presented to me information that there was evidence still to be tested, that there was forensically or otherwise, or witnesses that were needed that had not yet been obtained, I would have probably ruled differently. And so I just kind of want to make that clear where I was with these continuances. But I just felt like I wanted to clarify that. So go ahead, counsel.
Yeah, I appreciate that, Judge, and maybe leaning more towards my just feeling prepared to go to trial, and is why I'm making that statement.
I understand.
Overall, some of the facts of the case and how we've been here a few times for change of pleas and motions to suppress and whatnot. And every case that I've ever prosecuted, all of them invite appealable issues, and for whatever reason on this case, with these specific facts, it felt like the appealable issues were at the top of the surface. And what I'm think is strong is the plea agreement, and the defendant waiving those appealable issues allows for the family and the community to be a little more at ease, and they can start healing on their own rather than being surprised with something else in the future, as we know that can happen quite often. When we started out, trying to come to a plea agreement or resolving the case, whether it had to go to trial or through an agreement. A murder count was at the forefront. That gained the most weight, and that's because when I look at the investigation and the evidence that we have, the waiting, and Hope said that a little bit in her letter, the waiting, the preparing, the aggression that the defendant had in this situation, all of it to me absolutely amounts to murder. And quite frankly, I don't really know if we were to be able to put on the evidence, I don't know out of 100 people who in their right mind would see it otherwise. But the one thing that this plea agreement does for us is it guarantees that we have a murder count. And I think in our discussions, and not just in mediation, but even the months that followed, that was at the top of our list of checking the box off. Then there's the part of this case that in my 15 years of dealing with horrific criminal cases, this is at the very top of the list of what happened next with the dismemberment of the body that Shades spoke about. And somehow, under the Idaho law, we're only allowed to ask for 10 years maximum on that. And there's a $5,000 civil penalty. And this plea agreement for the 10 years gets us that amount. And we will be asking the court for the $5,000 civil penalty to be paid to the victims. One thing that they kind of addressed in the PSI, and both of the victims addressed, is that we would be asking the court for a no contact order with the family from the defendant because of he has been writing letters to them, and it's unnecessary at this point. In his mind, they might be trying to ask for some type of forgiveness, but what it's doing is further damaging the family. And so we would ask for a no contact order to be put in place. Then when I was reviewing the PSI, it was kind of surprising that he scored a 22 on the LSI score. And I say that because of a few things that I found in the PSI. One of them is on page 8. Under the box of emotional and personal, it's titled Emotional and Personal. One of the bullets, the second to the last bullet point, says he has considered harming others in the past for thievery of his property. And then on page 9, in the attitude / orientation, the second bullet point, he declared his biggest mistake was not calling 911 after he shot and killed Patrick. Even though he knew if he called 911, he was going to prison. Well, I would assume that his biggest mistake, and what he should have probably said, but he is not thinking, is that his biggest mistake should have been shooting Patrick. Or his biggest mistake should have been not calling 911 before Patrick came to his property if he thought he was such a threat. And so I don't know, and what was interesting when I was reading through that stuck out. I wrote it down to bring it up to the court, and then later on page 17, in the first paragraph on 17, the LSI writer or the PSI investigator also noted the same type of skewed thinking. And so my conclusion, without anything more but reading through this, is that on page 7 in the LSI scores, there's not a score for emotional and personal. There's no graph under that category. So I don't really know why that is, and I don't know if that would change the score a little bit if there was something there. But it is a question that maybe somebody can answer later. I guess another issue that I had was on page 8, where he says he doesn't think he would benefit from mental health counseling. And then he had an issue, I guess, when he was incarcerated before with not following the orders of the prison, and he wouldn't lift his tongue up. I did have some comments about his past criminal history, but where Mr. Archibald has brought up some questions of that, I will kind of glance over that. Just maybe in the conclusion on page 16, the PSI investigator does write, he does have extensive violent crimes involving firearms. With that, Your Honor, those are kind of what we've presented to the court in this plea agreement. We do think it warrants the 20 years that will take the defendant to 90 years old, and we're asking that to be a 10 fixed and 10 indeterminate. We're asking the court to follow that. We're asking the court for 10 years fixed on the charge 2, destruction of evidence, and we are asking for the $5,000 of civil penalty to be applied and given to the victims. And we're asking for a no contact order to be placed between the defendant and the families.
Counsel, that $5,000 civil penalty, I think, is also available under count 1 and count 2. What's the state's request in that regard?
We would request it for both counts.
All right, thank you.
Thank you, Judge.
Thank you. Mr. Archibald. And Mr. Archibald, if you wish, as to your client's request that we address regarding withdrawing the plea, I guess if you want to address that in your arguments to the court here, as to whether there's any, what just cause or manifest injustice you think he's attempting to avoid by withdrawing his plea, and if you wish to address it. Go ahead.
Yes, thank you. In the motion to withdraw the plea, my client would state that number one, this was an Alford plea, so he did not admit guilt. He maintained his innocence, and yet acknowledged that there was enough evidence to convict him. That's the elements of an Alford plea. So in his motion to withdraw the plea, he would state that he never did admit guilt to the murder charge, and so he would ask the court to let him withdraw that plea. He would also indicate that he felt that the court's rulings were on his motion to bifurcate and motion to suppress were in error, so that was additional reasons to withdraw his plea. That if the motion to bifurcate would have been granted, then he would not have entered his plea agreement. Additionally, he would have said that he received bad advice from his lawyer, and I indicated to him that I do not take offense when clients say that. I know that that's their right to maintain that if they had better legal counsel, that they wouldn't have entered their plea. And so I do not take offense at that. I respect my client's rights under case law, under the Idaho criminal rules. So those would have been the reasons. He would have indicated that he would have pleaded guilty to all charges other than the homicide charge. And that, in fact, was the first offer that he made to the state to settle the case. The state denied his plea request, and that's how we ended up with the plea agreement that we did. So that would have been the grounds for, and I'll let him address that as well as part of his allocution. That's okay.
All right, that's fine.
As far as the sentencing, the facts have been spelled out in the pre-sentence report as far as who was doing what. These were two former friends who then became angry at each other. They had bad blood. They were texting each other threats, and Mr. Bruce felt like he needed to obtain a weapon to defend himself against Mr. Shelton. Mr. Shelton always carried a weapon with him, a silver handgun. And in fact, when Mr. Bruce and Mr. Shelton were jawing at each other via text, that Mr. Shelton told Mr. Bruce to make his peace with God. Mr. Bruce thought that was a threat that Mr. Shelton planned to kill Mr. Bruce. And so Mr. Bruce went to his brother's house, obtained his weapon, and prepared to defend himself. But of course, hindsight, the better approach would have been to call the police, feeling threatened, instead of trying to take the law into your own hands. And so with these threats, Mr. Shelton then came on to the property where Mr. Bruce had been squatting, and Mr. Shelton came onto that property in early hours of the morning with his handgun, and Mr. Bruce fired first, and Mr. Shelton was killed. So if that's where the case would have ended, then I could see why a jury would think that self-defense was warranted. And Mr. Bruce explained to the police the self-defense. The problem with the self-defense claim is that's what happened after. And that's why the motion to bifurcate had been filed and argued with the court. And so what happened afterwards was Mr. Bruce dismembering and burning the body, towing the truck up into the forest, and then lying to the police about whether or not he had seen Mr. Shelton. So those actions could be taken by a jury as consciousness of guilt. So the risks of going to trial for the state, the risks of going to trial for Mr. Bruce were both taken into account when this case was mediated. So our mediation was from an experienced trial judge, and he could see also both sides of the story. That even if Mr. Bruce was successful with his self-defense claim on the murder charge, he could still go to prison for life due to the other charges: destruction of evidence, failure to notify of a death, and the persistent violator. So the persistent violator charge itself carries 5 to life. And so even if Mr. Bruce were successful with his self-defense claim, he could still serve the rest of his life in prison. And so those were motivating factors for Mr. Bruce and the state to reach an agreement at mediation to somehow split the difference, somehow reach an agreement that both parties could live with, that both parties were unhappy with. I think that's a sign of a successful mediation, is when both parties are unhappy. Mr. Bruce was unhappy that he had to admit to the murder charge. The state was unhappy with the short duration of the sentence. Taking into account, Mr. Bruce is 70 years old. He's in poor health. The pre-sentence report lists out his poor health. He has a pacemaker in his heart. He has medical issues. Mr. Bruce doesn't know if he's going to last 10 years until he's eligible for parole. And so because of those issues, his 70 years of age in poor health, then the 10 plus 10 years, a 20-year sentence with 10 fixed and 10 indeterminate, seemed to be a reasonable compromise to to Mr. Bruce and to the state. And so that's how those numbers were reached, Your Honor. That's how we came up with the plea agreement. And that's why we asked the court to accept the plea agreement if the court doesn't allow him to withdraw his plea. So I know my client's not happy with it. I know the victim's family is not happy with it, but that's how we reached this agreement.
All right. Thank you, counsel. Mr. Bruce, you have a right to make a statement on your own behalf. You're not required to do so, but now's your opportunity to speak directly to the court. If you wish, you may go ahead and remain seated and go ahead and make your statement.
Yes, it was under extreme duress that I filed, that I agreed to the plea agreement, because due to the extreme prejudice, what I did after I shot Pat Shelton, my attorney said he talked to 16 people in the field. They're all going, I don't know, it doesn't look good for your client. Detective Tuttle, when I tried to explain to him it was self-defense, when he heard what I did to Patrick Shelton, he says, oh no, I think you're trying to cover up a murder, and he recommended to the state that he filed a murder charge and I'd be prosecuted for first-degree murder. All I can say is that I observed Patrick Shelton hunting me down with a revolver in his hand that night before he got in his truck to go down to his place. I was walking back to my place, hiding from him, trying to avoid a confrontation. He pulled in on me. When I was trying to get, instead of driving around the circle driveway, he pulled in on me and my headlights were caught. He caught me in his headlights. I thought I was a goner. 5 minutes earlier, he had a gun in his hand looking for me. I threw my weapon up and I said, do you want some? Because I knew whoever gets to drop on someone else in a situation like that is going to either save his life, because if he doesn't, he's going to die. Well, Patrick Shelton, I cannot believe he did this. He unholsters his gun, pulls the slide back, and while he's saying, you better pull the trigger, he brings it up and is preparing to shoot me. I don't know if you guys know the terror of being at gunpoint once it's that close to being a heartbeat away from death. The terror I felt with, and my response was visceral. I'm sorry Pat Shelton did that. I'm sorry for his family. We were friends. To say I had no remorse, well, I feel for his family, especially for Hope. She's a good kid. I don't know her personally, but I understand that. Okay, I'll try to get by my emotions here. The other thing that caused me to, I had withdrawn my plea. I wanted to take it to trial. I wanted to show everyone here in this town that knows me, and I know that I did not kill Pat Shelton in cold-blooded murder. It was in defense of my life. And I wanted a trial. I don't care about the rest of the charges. I'm 70 years old. I figure if I get out in 80, when I'm 80, what am I going to do? Got no money, no friends, no place to go, nothing. I'd just be better off. A 10-year sentence is like a life sentence to me, even if I did live that long. So I wanted this trial to prove to everyone here in town that knows me that I know that it was self-defense, that the homicide was justifiable. I feel that my constitutional rights to a fair trial were denied when the court denied the motion to bifurcate. Pat's former criminal history had nothing to do with the facts. My former criminal history had nothing to do with the facts. The only thing that matters is what happened, what were the facts surrounding the circumstances of the homicide. Was it justified? Or was it murder? And in my case, I'm alive. I did not want to shoot Pat, but goddamn it, I had to save my life. And so, the plea was withdrawn until my brother, who was a staunch defender of me, Mercedes. Under the color of authority, he forged $3,500 worth of my checks, spent my money because I gave him my debit card and PIN to pay bills, spent my money however he wanted. He cut the locks off of all my storage facilities down there, 2 semi-trailer box fans and 2 Connexes and a old Snap-on tool van was full of tools. Cut all the locks off the gates, installed his own locks, and proceeded to help himself to about $40,000 worth of my valuable tools that I used to make my living.
Who are you referring to? Did
My
that?
brother, Brian A. Bruce.
All right.
I threatened him. I said, look, I said, Jeff Perkins going to come ask you for my stuff. I need to sell him my stuff so I'll have some money when I get out of prison so I can buy food and clothes and help myself. He changed his tune and said that we discussed me burning Pat in a barrel in his kitchen. That to me is like the ultimate duress that I could think of. And at that point, with my own brother testifying against me, whether it was true or not, I went ahead to accept this plea bargain because 10 years in prison is better than a life sentence. Well, I don't think it's fair, and I think that under the grounds that the state rejected my offer to plead guilty on all of the charges except the murder charge, and the advice of my attorney that we didn't do that, and the extreme duress under which I agreed to accept the plea agreement, that I have every grounds in prison to appeal my murder charge, which I intend to do, because as God is my witness, I did not kill Pat Shelton in cold blood. It was self-defense. I'm sorry, guys.
Anything else, Mr. Bruce, you'd like to say?
I think that's all.
All right. All right. Well, this matter needs to come to a conclusion. I'm going to readdress this issue regarding withdrawing the plea of guilty and address Mr. Archibald's statements in that regard and Mr. Bruce's statement. I do still feel that under the rule there has to be some showing of at minimum a good cause, but in this matter I still think that the standard would be a standard of manifest injustice, which is a much higher burden. First, I'll address the argument that because he entered an Alford plea, he would like to withdraw his plea because he's always maintained his innocence. I'm aware personally of a case called State v. Dock where that very issue was addressed, where it used to be the law in the state of Idaho that if you entered an Alford plea, under the rule, you would have an absolute right to withdraw your plea without making any kind of a showing of good cause or otherwise. The Supreme Court changed that law in State v. Dock and stated that even with an Alford plea that is showing the same standard must be met of either a good cause prior to sentencing or manifest injustice after sentencing. So the fact that he's simply entered an Alford plea to the court is not a basis of a showing of good cause or manifest injustice to withdraw a plea. During his guilty plea hearing, the court very clearly went through with Mr. Bruce, and he was under oath at the time, making sure he understood he was waiving his defenses that he thought he had in this case, including self-defense, by entering this plea of guilty. He understood that he was waiving the right to appeal the court's decision regarding the motion to suppress, and also the motion to ask him to bifurcate the charges. And so I think it was very clear in the record that he understood that and was entering that plea knowingly and intelligently with that understanding. So I don't think that now at this point in time to come back and say that he didn't understand that or he still wishes to just simply appeal those things is not a showing of good cause. And just to clarify, Mr. Bruce made a comment that he didn't think his criminal history or Mr. Shelton's criminal history would be relevant and shouldn't be presented, and he's absolutely right in the general rule, and the court made no such ruling that the criminal history specifically would be presented to the jury only under whatever limited circumstances or exceptions that would apply under the rules of evidence. And I, in fact, did bifurcate the felon in possession of a firearm charge just for that reason, so that the jury in the case would not be aware that he was a convicted felon and could not be in possession of a firearm. So I, in fact, did bifurcate that charge from the others. As to the ruling, as to the bifurcation of the destruction of evidence from the second-degree murder charge, I'm confident in the court's ruling in that regard, that the evidence as to the destruction of the body, the failure to call the police and to lie to the police initially about what happened would all be relevant, even as Mr. Archibald stated, the consciousness of guilt issue would be present as to those actions that he took, and would be relevant, and relevance, any prejudice under Rule 403 would not outweigh the relevance under 401 of the Idaho Rules of Evidence. So I believe my ruling was correct in that regard on that matter, and so I don't believe there's any basis to allow the withdrawal of plea under a manifest injustice basis or otherwise. The issue regarding advice of counsel, I guess, is something that Mr. Bruce can take up on post-conviction relief, because those are alleging matters that are outside the record in interactions between Mr. Bruce and his attorneys is all classic ineffective assistance arguments that need to be brought in a post-conviction relief setting, and the court's not going to consider it here in the context of a request to withdraw a plea. So I'm again just making a record as to why I'm denying the motion to withdraw the plea here today, and that we're intending to proceed with this sentencing hearing. I've heard all the statements, and I appreciate the victim's statements that have been made here in court, and that is one of the things that the court is directed to consider. Under Idaho Code 19-2521, the factors that I consider in determining whether to, in this case, whether to accept this plea agreement that's been reached in this case. And I have considered all of those factors, including the impact on the victims, the protection of society, imposing a sentence that doesn't minimize the seriousness of the crime, and I'll address that in a moment. Deterrence to Mr. Bruce, deterrence to others in the community who may engage in similar conduct, and punishment just for punishment purposes for the nature of the offense. The aggravating factors the court considered, in my view, Mr. Bruce, as has been commented on here by the victims and others, that this is a case where obviously better judgment would have been for you to contact law enforcement to obtain their assistance. Your refusal to contact law enforcement and try to get their assistance is really, I think, arises out of your own personal long history of antisocial criminal behavior, where you don't feel like you can interact with law enforcement or that they won't help you, but that's of your own doing, and unfortunately you have placed yourself in that situation. And unfortunately Mr. Shelton was in that situation where you exercised that poor judgment in not contacting law enforcement to get their assistance with these issues that you claim were happening. You instead took a substantial amount of time to premeditate how you were going to basically stalk Mr. Shelton and go and confront him for what you thought he was on your property or coming to do. You went and obtained a rifle from a third party, and apparently made the comment that you'd gone to obtain weapons, and used the comment of artillery, I guess, to go get what you thought you needed to then go confront Mr. Shelton. You got night goggle visions to use to go back and basically stalk and see what he was doing. Again, all instead of contacting law enforcement. You claimed to be afraid of Mr. Shelton, feared for your life, yet still willingly went back and basically put yourself in the position of interacting with Mr. Shelton, and basically became the aggressor, the first aggressor in this in this scenario when you had plenty of time to contact law enforcement. So there's actually lots of premeditation in this case. The destruction of evidence, obviously, and the dismemberment, burning of the body, it just goes without saying how heinous that conduct was and what kind of person is going to engage in that sort of conduct. I think just cries out for a severe sentence that could be imposed, and the impact that it has on the victims and just society as a whole. Your entire premise of your case, Mr. Bruce, has been premised on the basis that you feel like you were acting in self-defense. And I wholly disagree, and I think that a jury would disagree with you. I believe that you, as I just pointed out, were the initial aggressor in this case by going back onto the property, even though it was your property, or at least you were living there. You had left the property, you went and got a firearm, came back to the property, you came back, you went to the fight didn't come to you, you went to it. You intentionally went back there with weapons and with the night vision goggles so that you could put yourself in a position to confront Mr. Bruce. And so, in my opinion, the case law does not allow someone to basically stalk someone with night vision goggles, go obtain a weapon, and confront Mr. Shelton with that weapon and still claim that you're acting in self-defense. In fact, there's case law and the jury instructions in self-defense would indicate that if you are the first aggressor, determined to be the initial aggressor, that you would not be entitled to many of the self-defense arguments that you would be attempting to make and that you're attempting to make here in court today. And I believe the evidence shows that to be the case, that you were the initial aggressor in this case in the way that you went back to the property and confronted Mr. Shelton when you had full opportunity to go to the police. So with that, it's the court's view that this plea agreement has been offered to you is really a blessing, because you were otherwise looking at a conviction on a first-degree murder charge, in my view, for the reasons I just stated, that I think you did not have a viable self-defense argument, and this court very likely would not have been willing to give the stand your ground self-defense type jury instructions that you were hoping for in this case, because in my view you were the initial aggressor and you did not separate yourself from the confrontation or attempt to do so. And so again, I think that this was a very strong case for the initial first-degree murder case, but there are challenges in every case, and there are issues that both sides need to consider in deciding the viability of their case and the merits of going forward versus the merits of settling. And I accept the fact that in this case that there was a mediated agreement here that the victims participated in. They may not totally like this agreement, but it's one that was apparently agreed upon. And so the court is going to go along with this agreement really only for those reasons, and the need to get this matter resolved, and the fact that Mr. Bruce is 70 years of age and he may not survive even a 10-year fixed term. But I do want the parole board to know, and I'm making a record today, that I don't particularly like this plea agreement, and I don't like the outcome of this case for the reasons that I've stated, and I do believe that a more severe penalty would have been justified in this case when it comes time to eligibility for parole, because I do not think you acted in self-defense in this case under the case law that the court's familiar with. I think that a more severe penalty, had you been convicted of first-degree murder, would obviously have been probably potentially a fixed life sentence, or 25 fixed, something of that nature. But I am going to go along with this. I am going to accept that the plea agreement is presented to the court. So Mr. Bruce, is going to be the judgment of the court that you are in fact guilty of the crime of murder in the second degree as you entered your plea, and you are in fact guilty of the charge in count 2 of of destruction of evidence. As to the charge in count 1, I'm sentencing you pursuant to the plea agreement to a 20-year term of incarceration with the Idaho Department of Corrections. 10 years of that sentence will be a fixed term before you're eligible for parole, and then an additional 10-year indeterminate period to follow should the parole board deem it appropriate to consider you as a candidate for parole. As to count 2, I'm sentencing you to a fixed term of 10 years pursuant to the terms of the plea agreement. Both sentences, again, pursuant to the terms of the plea agreement, will run concurrently, meaning they're running at the same time. Again, as to count 1, I'm going to impose the mandatory court costs. I'm going to impose a $5,000 civil penalty in favor of the victims. I'm going to give the state 30 days to file a motion or request for restitution for funeral expenses or other items that would be legitimate restitution requests, and they file that with the court. And we'll have further hearings if necessary if there are objections to the amount of restitution that's being requested. I'm going to order the amount I order in every case, of $500 reimbursement to the State Public Defender's Office for the cost of court-appointed counsel on that count. As to count 2, I'm also imposing the court costs in that matter. I'm also imposing the $5,000 civil penalty in favor of the victims on that case, and there'll be 2 separate penalties for the 2 separate counts. And again, any restitution may be similar to count 1, but be given the same 30 days to file any restitution requests. I'm not going to impose an additional $500 fee in both cases were counts being tried together within the same case number, so that would simply be a one-time fee. I'm going to impose a no contact order for the duration that the court is allowed to by law, which would be 20 years, which is the duration of the sentence. That's the extent of the court's jurisdiction. And so I'll impose a no contact order as to the victims who made statements here in court today, and any other members of Pat Shelton's immediate family or his ex-wife or other. So they'll be included in the no contact order, Mr. Rogers. Anything I've overlooked, Mr. Rogers, under the terms of the plea agreement?
No further statement.
Mr. Archibald, have I misstated the terms of the plea agreement as far as the sentence that I imposed in any way?
No, Your Honor.
All right, Mr. Bruce, that's the sentence of the court. You do have a right to, you have waived your right to appeal under the plea agreement that has been entered in this case as to the sentence imposed in this matter. And so you've waived that right to appeal. You've also waived your right to present a Rule 35 motion requesting leniency from the court in the terms of your plea agreement. I will advise you, you do have certain rights under Idaho's post-conviction relief statutes. If you do feel your constitutional rights have been violated in some way, that's a separate cause of action or claim. It's actually a civil case where you would become the plaintiff in a case versus the state of Idaho. It's called a petition for post-conviction relief, in which you would have to set forth your claims and be subject to a whole separate action depending on the merits of your claims. But you do have a right to bringing an action for post-conviction relief. There are time limits for bringing that claim. Since you've waived your right to appeal, you have 1 year from today's date to file a petition for post-conviction relief. So do you understand that right, Mr. Bruce, as to your post-conviction relief?
I don't really understand it, but I'll get educated.
All right. That'll be the order of the court. Hopefully this matter can bring some conclusion or some finality to this matter, and that everyone involved in this case can begin a healing process of sorts as best as your ability. But I do appreciate the statements provided by the victim's family in this matter. I appreciate counsel's work and their efforts in these cases. They're difficult cases for everyone. A lot of moving parts, a lot of things to consider, a lot of emotion involved, and it's a difficult work for everyone. So, but I do appreciate that. I don't think there's anything further for the court to take up in this case, so we'll be in recess.
Please rise.